Okay, everyone, we have October the 21st, 2020, and this is the Brilliance in Commerce, Private Placement Platforms, House of Freedom International Natural Law Trusts, Building the Foundation for the Golden Age. I'm Tansen Fairmont, and it's a nice privilege to welcome you today. Thank you for joining us. So, as you may know, we cover the trust topic today. We also have Liberty Debt Elimination Systems. We have affiliations and special offers with all kinds of very, very nice asset protection and wealth building programs. We are members of the Worldwide Charter for Fair International Commerce, the complete description of which you can see on the website. So take a look sometime if you haven't. It's a very worthy organization. Today, October 21st, where our next webinar on this same series will be November the 18th, 2020. And to play past webinars, go to brilliance-videos.com. That's brilliance-videos.com. You can see all the past YouTube posts of these monthly webinars. For those who need a phone number for our company, that's 360-200-7521. And for those who have an interest in acquiring a trust, we recommend that you go through the affiliate who referred you and use their link. For those who reached us without any affiliate link, you can use house-of-freedom-trust.com. My name is Tansen Fairmont. I'm the founder and consultant and speaker on radio shows, former offshore investment seminars, author of Sovereignty Consciousness and Cosmic Renaissance. Randall Hillner is our main speaker today. And he joins us from Hawaii. He's the director of the trust department at Brilliance in Commerce. He's the founder of House of Freedom Trusts, founder of White Light Unlimited, One People's Public Trust trustee, creator of the International Natural Law Trust. We have someone working with Randall, Dominique Hackett, my good friend in Santa Barbara, who is an assistant who also assists with trust formation and teaching for those who become clients. She provides a monthly trust study group webinar, and that is open to those who have acquired a natural law trust. Those webinars are fantastic, and they go deeper into the details of trust structure and operation. Today's topic is the Law of Trusts, Part 1. And this will be a very nice overview for basics as well as advanced information. For those of you who have been attending these for quite some time, you'll recognize some of the basic information, but it's always good to review it and get a new angle on it. And then the advanced information will be sprinkled in as well, all of which is necessary to understand the best use of these trusts. So let's see, Randall, I am unmuting you and inviting you to
Good afternoon.
Turn on your video. Good afternoon. Can hear you nicely.
What a day.
Can everyone else see Randall's video? Because some reason it's not showing up for me.
Really? Maybe I should get my head out of the water. Or at least eyeball level.
Well, do you ever get your ears logged with water in the ocean?
Oh, yes, yes, yes. And my sinuses, I have to be careful when I bend over sometimes.
Okay, other people are writing that they can see you just fine. Very good. So Here is the first slide.
Oh, the beginning of this whole process. Okay, so what we have is there, we can call it 3 hats or 3 essential ingredients or however we want. And I'm going to basically talk about it as being a hat. And just to make it clear that we can change hats all the time, and we have to be careful when we take off one hat and put on another. So the first hat that we all have to take is that that is who is going to create this whole trust. And typically that is the client coming from or to Brilliance in Commerce, or clients coming to me specifically from other sources that I work with. But the idea is that somebody has to be the settlor or grantor, or certainly the nominee, settlor, or grantor to begin this whole process. And what that settlor does is he creates a contract in which he wants to make a name for the trust. He wants to appoint who the trustees would be, and he wants to establish who the beneficiaries would be. So that's just the beginning of the whole process. And then in order to facilitate that, of course, you would receive a client form, and in that client form is you would see spaces where you would establish all these participants, or the 3 different hats that we're going to talk about today, and certainly in brief or in general form. And then we will go deeper into the particular hat and what's in the hat and what needs to be done with the hat that you're wearing. So we're going to start there. In the settlor, what you have to realize is when you're a settlor, for our document that we are going to create, or you're going to create and be participant in a private irrevocable trust. This private irrevocable trust is a private irrevocable contract between yourself, some trustees, and some beneficiaries. So you need to be aware of what role that you might want to play in this scenario. There's going to be options, which we'll talk about later, but the first role is a settlor. And if you're a client, then you need to consider, and if you've been listening to these seminars that we've done, then I think you'll mostly understand that the settlor is the beginning process of this. Then we go from the settlor, and you have to think about, okay, who do you want to have as trustees? Do you want to be a trustee yourself? Who are the beneficiaries? What are the rules about being a settlor and a trustee and a beneficiary, and how those will all interplay with each other? So there's that little bit of an introduction. Maybe slide number 2. Okay, the client is the grantor. This is in the beginning days, way back. Don't want to say how far. Typically, our client was going to be the grantor. And then we would, in the early days with the people I was working with, we would set up and either become trustees ourselves, or we would find suitable nominee trustees, and then we would either teach the trustees or we would play the role of trusteeship for the client. And in that process also, so the client would agree to being the grantor. He would also have the ability to look and see if he wanted to have another nominee grantor that would take his place, so that maybe he could play an additional second role um, and who was going to be the beneficiaries, who were the beneficiaries. Was he going to be the sole beneficiary? Was his children going to be, or family going to be the beneficiaries? Was he going to include humanitarian projects as beneficiaries? So these are things that as a client or as a grantor, you would need to think about and discuss with us here at BIC, or once you become a client, then you would have access to my consulting and we would discuss it on a more personal level. And then you would get to choose out of that. You would begin to understand, okay, who would I like to have in the role of all of these three different hats? Those three different hats being the grantor, settler grantor, the trustee, a co-trustee, and or a beneficiary. Now we're going to go a little bit into how many of those hats you can wear at one time. But first, right off the top, we'll say that you cannot wear all three hats at one time because it negates the ability to have separation, and you need to have separation between you and the assets so that you can actually create a legally binding contract. So there it is, you as grantor. Next slide. Nominee grantor. So here's one of our first thoughts is that you as a client will have the choice whether to have a friend or a family member that may or may not be one of the beneficiaries, or a service that we provide here at Brilliance in Commerce. So the nominee grantor would be somebody that steps in, creates this powerful document, and then obviously all in an irrevocable trust, the nominee grantor, whether it's a nominee grantor or the real grantor, would relinquish all control over the process that's going to happen for this irrevocable trust. Now, before he signs that document or goes into this, he's going to have to understand, and you will understand, that when you relinquish control, that you do relinquish the ability to take back any assets that you might have put into this trust for the sake of the beneficiaries. And you can be clear about that with watching past seminars, what I'm going to talk about today, or personal consulting with me as a trustee mentorship. So the nominee grantor can be somebody that we help you appoint, somebody that you appoint as a friend or somebody within your family, or something else altogether. In other words, some of you might have a trust from a prior experience, and you want that trust to be a nominee grantor, which is certainly something that you're able to do. So the nominee grantor can be fulfilled in a number of ways. And if you need more specifics than that, then write your question down and we'll go into that towards the end of our conversation here. Okay, next slide. Here it is. We're just reiterating again that a friend or family member can be grantor. So this all depends also on, we're talking about possible a family member being a grantor, then it's important to note that that family member cannot be a sole beneficiary. Or if he is a sole beneficiary, which can happen, then he would not be able to be a trustee to fulfill the role of not wearing three hats. This is the important aspect of this whole concept, is that you cannot wear all three hats because there's no separation. So 2 out of 3 is okay, but choosing the right 2 out of 3 is something that you need to consider, something that we can do at BIC, and something that I would certainly do with you on a personal level once you become a client with us. So friend or family member is grantor, nominee as a grantor, those are all suitable hats to wear, and you should have enough from this brief little uh, conversation where you have some sense of who you would like to be as the grantor. Okay, next.
Let me just mention for newcomers, if you have questions about anything Randall is saying, you can be thinking about them, write them down. You can put them into chat if you're viewing on a visual device, or write them down and save them. And about another 15 minutes or so, we'll open it up to questions and answers. So have your questions ready. Thanks.
Corporate grantor, yes, of course. It could be a corporation. I've used a number of instances where either an S Corp or an LLC, which is a state entity, and state entity gives some sense of liability protection. And you wouldn't use the trust as a corporate grantor, although it can be also, but a corporate grantor would be something like an LLC or an S Corp, or perhaps you already have a corporation established and you would like that corporation to establish a trust that's separate from the corporation to give some of the assets some separation. So the corporation would create a trust, would be the grantor. It would choose trustees, perhaps somebody within the corporation, perhaps somebody else, and then the beneficiaries would be somebody else entirely. Could be the beneficiary is the corporation, and so it makes a roundabout way, maybe refunds itself, so it could do that. But basically, yes, you can have a corporation or some state entity corporate form be also the grantor. Next. So we've have an understanding of grantorship, settler, grantor, creator, very interchangeable words. They all mean the same thing. You're basically establishing the contract between yourself, trustees, and the beneficiaries. So how many trustees do you need? Well, essentially you need to have at least one trustee, somebody that can be separate from you or the beneficiary, that steps into the role of a fiduciary capacity. So because we have a complex discretionary trust, which we'll talk about not necessarily right now, it may be in another part, I may be able to get to it later, is that a private irrevocable discretionary trust allows the trustees significant latitude as to whether they pay the beneficiaries when maybe they need it, when they need some assistance, when they don't need, maybe one beneficiary needs more assistance than another. So the trusteeship role is one of being able to understand the use of these trusts. It's a little more complex, Shirley. It's very much more complex than a standard revocable trust where you can wear all three hats. It's the only thing that a revocable trust does is it does eliminate probate. But other than that, there are no tax benefits. There's no, it's not as protective because you wear all three hats. It can be gone into, and some of the assets can be attached because it's not a private irrevocable trust. And so if you have all control of all three hats, then it really is not separate from yourself. So we have 1, 2, 3 trustees. Most people have one trustee, or if you're deeply involved with yourself as a beneficiary, then I highly support or suggest that you be a co-trustee, that you have a second trustee that's not related to you. And so it offers a adverse relationship. In other words, that person, because they're not related by blood, marriage or employment, was not necessarily afraid to say, no, you can't do it this way. We must treat this as a fiduciary responsibility, and therefore we have to follow certain guidelines and rules. So 1, 2, as a co-trustee, I've set up where we've actually had 4 trustees, but to me, that gets a little bit too complicated. I'd rather 2 at the most. Sometimes 3 helps if it's a rather large asset base, and so there's an odd number. So when you have 2 trustees, it has to be unanimous decision to do this, to make a decision or take action on the decision. If you have 3 trustees or an odd number of trustees, then it basically is the majority. So in most places, it's either 1 or 2 trustees. Okay. We just touched upon that. A friend or a family as a trustee or a co-trustee, perfectly viable. And when they step into that role as a co-trustee or a trustee, then they really have to be educated that they're not just coming in as your brother or your mother and you're going to be able to dictate how you want them to act accordingly. They're going to come in a fiduciary capacity, and they're going to make sure that if you receive funds as a manager or as a fiduciary trusteeship yourself, that it's paid as a fiduciary and not as a member of the family. So it's not like an allowance. It's the fact that the co-trustee must make this diligent decisions on how the payout is happening. Doesn't mean that it can't happen. Doesn't mean that we can't do certain payouts more than others, but you must make a decision when you have the hat on as trustee. You must make the decision as a trustee or in a fiduciary capacity and take responsibility for good faith and reasonable care in the decision that you're making. Okay, slide. Some of you might choose to have successor trustee. Let's say that you want to be just the sole trustee in present time, that you have specifically had a client, he had 4 children, he wanted to be the sole trustee, he didn't want to be the beneficiary. We're setting this up strictly so that he could have control over how his beneficiaries would receive funds. So he knew enough about trust law and about how to run his trust with some coaching for me on how to exactly pay out the different beneficiaries that he had in his family. If everybody was equitable, which he did in the beginning, he made everybody, the same ratio, and he would pay that ratio to everybody based on whether it was a monthly payout, quarterly, yearly, etc. But he also knew that if there was one beneficiary that either needed more educational facility or possibilities, or one of the beneficiaries needed more health care, that he could participate in that and give that particular beneficiary a more of a stipend. Now, along the line is that most banks today and most courts, if you even get that far, are going to want to have or understand who is going to succeed you in case you become ill or incapacitated in your ability to be a trustee. And that often happens. Could just be a week. You could be down for a couple of weeks with all the stuff that's going on. Who knows? But there needs to be somebody that has the ability to step in case of your capacity to act either on a momentary basis for a particular period of time until you can be active again, or to take on a substantial role if either you might say, no, I don't want to do this anymore. I can't do this. I need you to step in as successor trustee. Sometimes you might have one successor trustee. Sometimes you might have two or more. But basically, you need to have the name of at least one person somewhere in the record book that would pick up and be a successor trustee in case of your incapacitation. And if you're going to have a successor trustee, then it's appropriate that person also would listen to these webinars that we do, and you would help educate that person to step into the role as a trustee. At some point, they will have to. Okay, slide. Powers and duties of trustees. Okay, the really, I think the uniqueness of the document that we have has a list of powers in one section and duties of the trustees in another section. The powers are defined. They're not necessarily powers in general, but they're defined accordingly, and each one specifies a particular thing or activity that the trustee can do and will want to do or want to include in his performance as a trustee, whether it's to enhance the asset, to dispense of an asset that possibly is not performing, and how to set up a distribution to the particular beneficiaries. And his duties significantly are recorded again in another section, and so that he would have a list of what it is that he's expected to perform as a trustee. It's not lengthy, it's not complex, but it is something that he would have to understand, and we all need to understand the significance of what it is in that trust document. I was just reading again today, or last night, I was looking at exactly those things, and not only the powers and duties of the trustees, but also the rights and powers of the beneficiaries have in their hands. And we will delve more into beneficial powers and duties as well into the future, if not tonight. Next. There it is. What a lead in. Client and others as beneficiaries. Okay, well, as I just talked about, the client oftentimes is the beneficiary. That may be himself. It may be himself and his family. It may be himself, his projects. It may be just not even himself, but family members and or humanitarian projects. A number of you are out there are setting this trust up so that when this potential reevaluation exchange happens, the trust is in place, and instead of coming to you, the potential of significant financial gain is not coming to you, but it's coming to the trust, and therefore it is not tied to what happens to you. If you own it when it happens, then you may be subject to tax liability. If something happens to you, it may be, and you can't actively have a duty to fulfill it. It may go into the court system, which you don't want either. So it's important that as a client and a trustee and as a beneficiary, that you have looked at and read the document that specifically deals the powers and duties and what the beneficiary can do to make demands on the trustee. Next, please. Rights and powers of the beneficiary. Okay, so typically when you're the client and certainly in the early days, the trustees would take over and basically make the investments for you. You might give an outline of what you would like to see happen if you already had a particular asset-based wealth management in place, you would make sure that that particular asset would be assigned to the trust. So the trustees would take that asset into the trust. You would continue to be the beneficiary. You may have other beneficiaries in mind that you want to also have them participate in the ability to receive beneficial interest of what it is that you set up, the wealth management process, insurance, or things like that. Insurance typically can be paid for by the trust if the beneficiary of that insurance policy is the trust, then that's a viable option as well. So you have all these rights and powers of beneficiaries. You have the right and the power to not dictate what the trustees do, but you do have the right to make them accountable and have them account to you what it is that they're doing for your benefit. So they owe you some reporting, specifically at least once a year. If there's a lot of activity in the trust, then it could be on a monthly basis. Certainly, you would have an understanding of what actions are being taken by the trustees to help either protect the assets, to enhance the assets, or to shed the asset if it's not a viable process anymore. I love that sailing vessel. I've been on those. They are magnificent creatures to sail.
The beneficiary is waiting for her ship to come in.
Oh, the ship has arrived. It's on a port tack, obviously, with running quarters, going downwind, offwind, as they say, running port downwind. And she is relaxing in the shade of an olive tree or a palm tree. Okay, next slide, please, if any. The spendthrift clause. Ah, you nasty booger. Don't try to spend more or be frivolous with your beneficial interest. So within our structure is a particular clause, but there, in some instances, they actually would create a spendthrift trust, which is specifically just for the wayward beneficiary. Maybe there's two beneficiaries, maybe there's one, but he's either not of age or he may not be astute in his ability to make proper decisions on the management of his wealth. He may be frivolous. I won't go into that, what that frivolity might represent, but in the clause, in the section of the trust, we do have a clause that specifically says if the beneficiary is not watching what he's spending money on, or he gets sued and they try to take his beneficial interest away, that the trustees have the right to withdraw his beneficial interest until his resolution on the matter, and it can go to another beneficiary, or it can be held within the trust for a certain period of time until the discrepancy with this wayward beneficiary has been taken care of. So the essence is right there, is that this is to protect the assets of the trust from being frivolously scattered to the wind. Okay. Oh, well, there it is right there. That's one enjoyment. I'd rather be on the sailing ship, but some people like to fly. And actually, my son used to fly one of those, and I got to have that co-pilot chair, and I got to jump out of one of those. Anyway, that's neither there nor there. So the benefit of enjoyment is the trustees can, depending on the asset base of the trust, it can be as extended or collapsed as needed to be. Some of you will have trusts where there's only a certain amount of asset base and the asset base is small, but it does give you, it puts food on your table, it takes care of your medical bills, it takes care of your clothes, you know, and your rent, food, and some clothing, as we used to say in an old group of mine. So that's what you get to do. And depending on the asset base of the trust, as it grows and grows and grows, then you have more enjoyment. The expansion of that enjoyment can lead further into more things, more estates, or whatever it is that you have a fancy for. Okay. So hopefully we've got some questions.
Yeah, so as you may know, if you're looking on a visual device, you click on the raise hand icon or type it into chat. And if you're listening on the telephone, you can press *9 and that will raise your hand, and then we can open your mic up and let you ask. Randall, it's useful mentioning perhaps for newcomers especially that as far as I know, we're one of the few, if not the only, trust writing groups in the world that allows the client to have a choice of being the trustee.
I don't know about anybody else, but that is one of the concepts that we really hold as a viable process that makes our trust so valuable, is that the client can choose to be either a grantor or a trustee or a beneficiary, or two out of those three, not three, but two out of the three. So it's really unique. And a lot of places, a lot of my history, trust here, trust there, and they make sure that they have more control over the process than you do. And so it's really not nearly as unique as having it set up properly with us, so that we can direct you and make sure that you have, you have the ownership is within the trust, but the control is within you and or your trustees, and the benefit is with you and or other appointed beneficiaries. So it's really unique. And back in the 70s when I started this, my mentor had come from the 50s and 60s, and talked to somebody yesterday on a phone call, and I said, you know, first thing I had to do is go buy a 20-volume set of Scott on trust, and that was what I did. I was building houses, raising a family, and sitting down at night reading 200 pounds of trust books. And hopefully, as a client of ours, you don't have to do that. That's why I'm here, and I'm trying to have you consider coming with us, and I would do all the research and you would get the benefit.
All right, we have some questions. Margaret has asked, can a trust exchange an asset, for example, a house, into another trust, or exchange funds into another trust?
Yes. If beneficiaries stay the same, yes, that could happen. So you could take a house or an asset, and another trust would be created, and it would be assigned, and trustees and beneficiaries would all agree that yes, we're going to do that, we want to do that, and so then the second trust would happen. Now, I wouldn't say that you would want to do that with just one house or one wealth management asset, but let's say that there's 2 or 3 houses within the trust, then yes, let's create a second trust or a third trust and take all 3 of those houses and put one each in its own trust. And That way, if something happens on one piece of property, it won't affect the other two. Whereas if you have all three assets in one trust, then if something happens on one piece of property, um, it could affect the whole asset base of that trust. So that's what we're talking about with multiple trusts, is having those assets separated. We talked about the Rockefellers and the Kennedys and all those people have hundreds of trusts because every time they got an asset, they separate it out so that the base stays relatively within reason, and all new bases are on their own entity. They're in their own space. That's the reason that we separate things out. One house, not a reason. We're talking about, sometimes people say, well, what about putting my car in trust? I say, never put anything that can create damage into something where you have an asset base. So you would never put an automobile or a vehicle, something that can cause damage, into an asset, because it subjects the asset to that liability. Next.
Okay. Amarval, hi, how are you? I'm glad you're joining us. She asked, is a nominee settler grantor and instead or and as well as? Do you understand the question?
A nominee grantor would, we have that service. What that service does is it creates a trust, and then within 3, 4, 5 signatures, then they have relinquished all control of their process within the trust, and they're gone. That's as a nominee grantor.
Would there be more than one grantor? And maybe that's what the question is getting at.
No, one is all that's needed. The nominee service, nominee grantor service is an entity that has the ability to be a nominee grantor. It's an entity.
Name only.
Yes. And they're gone.
Right.
So then it's up to, it's all between the trustees and the beneficiaries. And that's ultimately how you want it anyway, because even if you're the grantor and the beneficiary, then you've given up your right and power as a grantor. You have turned it over. It's an irrevocable private trust. You've given up all control of being the grantor, and you now only have the rights and powers as a beneficiary and or as a trustee.
Okay, JB asks that beneficial enjoyment applies to beneficiaries only?
Yes, pretty much. Well, the trust does have has a section where that any charitable interest that the trustees and beneficiaries might have is an allowable deduction for the trust. So the trustees can say, well, or the beneficiary may want to support certain charitable process, and that's very allowable through this trust.
And Ken asks, how can it be possible to be both the beneficiary and the trustee at the same time?
You could be you could be the grantor. You could be a trustee if you're not a beneficiary. But if you're going to be a beneficiary, then I would take the hat off. I wouldn't suggest you being a trustee. You can't wear 3 hats. So choose to be a grantor and a beneficiary, or a grantor and a trustee, but you can't wear 3 hats. Trustee, beneficiary, grantor, beneficiary.
Well, this question is about being trustee and beneficiary, and you've said that that is possible as long as you're not the only beneficiary, right?
You can't be the sole trustee and sole beneficiary. That is correct.
I think he's asking, how can you be a beneficiary and also a trustee?
You would set that up, and when you talk to us at the DIC or myself, then I would say, okay, what hat do you want to wear primarily? So you want to be a grantor? Do you want to use a friend or a service? Do you want to be a trustee? You can be a trustee as long as either, if you're going to be a beneficiary, that you have a co-trustee and you have perhaps other beneficiaries. You just can't be all three, and you can't be sole trustee and sole beneficiary.
All right. And Eric says, do you have to have different trustees for multiple trusts?
You're going to have, or I'm at least going to suggest that you have at least one new party to the action. So say you have a string of assets that keep on multiplying and you want to create new trust and separate it out. It's okay for your main trustee. You have a trustee that's you like working with, or you might be the trustee. If you do if other trusts are created, then I would highly suggest that you have a co-trustee that's new to each trust.
And Margaret asked, you said as long as the beneficiaries stay the same, do you mean relating to the trust doing the exchange or the trust which is receiving the asset?
Would you run that by me again, please?
You said as long as the beneficiaries stay the same, do you mean relating to the trust doing the exchange or the trust which is receiving the asset?
Well, the trust is doing the exchange or has the assets already. So question doesn't quite make sense to me. The assets are already assigned to the trust. So that's basically, the beneficiaries can be the same and the assets either are already in trust or they're going to, but there wouldn't be a trust unless there's an asset in it.
She's referring to when a trust is exchanging an asset to another trust.
Well, some of that asset must follow into the new trust. There has to be an asset in the new trust.
Right.
So I wouldn't create a new trust and move a whole asset from one trust into a second trust. That doesn't make any sense. If you're splitting the asset, it's a splittable asset, wealth management or something, then yes, it's totally viable. Let's say that the asset somehow is a significant gain, then yes, take part of that asset base and create a new trust. And one of the trustees or beneficiaries can be the same on the new trust, but there's a new asset and I'm suggesting that there also is a new secondary trustee or at least a secondary successor trustee.
All right, here's a good question. How could one be denied access to funds in a worst case scenario? I'm assuming the questioner is referring to beneficiaries.
Well, if you're very frivolous and you piss away all your funds, then the trustees have the right to say, I'm sorry, until you grow up a little bit, we're going to withhold these funds. And when you either mature or show that you've corrected your misbehavior, then you will be made available to the beneficial interest again.
In other words, it's subject to trustee discretion.
That's why we call it a discretionary trustee power.
Mm-hmm.
So there's two things. There's one of the new books I'm reading is Equity versus Common Law, and they're very distinct in the way that trust law is formed. Equity is based on the asset, and the common law is based on a judicial process. So that will be a topic that probably is going to happen either next month or the beginning of the year. It's quite unique, actually, but it's essential. And within the trust document in itself, it talks about equitable interest versus beneficial interest or legal interest. In other words, in a fiduciary capacity, the trustees have a legal ownership of the asset base. However, their duty, their fiduciary responsibility and duty is to protect those assets and enhance the asset and make them available ultimately to the beneficiaries.
The same questioner asks, how can the client be denied access to funds in a worst case scenario?
Just that, well, look, is the client a beneficiary? Because if the client's not a beneficiary, then it wouldn't matter. The client is typically a trustee or a beneficiary.
And if the client is the trustee, then that wouldn't happen, I guess. Huh?
Well, again, if the client becomes the trustee, then they're under a fiduciary responsibility to the beneficiary. So if you decide to be the trustee, and it's important that you get that it's a responsibility and you're under a fiduciary legal process. So make sure you're aware of that and talk to me or somebody about that. And we can explain it further in another seminar.
But there's no outside power that could deny that trustee access to the funds in the trust.
Not unless there's fraudulent behavior going on. That's correct.
Right. Okay.
Nobody else owns it. So the trustees own it. They have legal title to the asset. It's the boat right there at harbor. The trustees own that boat legally. They have legal title to the boat under the name of the trust. And their job is to protect that boat, keep the upkeep, keep it from leaking, keep it from sinking for the use of the beneficiary.
Thank you. Okay, we have a hand up. So area code 323, I've asked you to unmute, and you are welcome to unmute yourself, and then you are on the air. Area code 323, are you listening? You are asked to, okay, there you are.
No, fine, thank you. Gerald in California. A question, the trust, is it registered anywhere in case an outside entity wanted to confirm its validity?
No, it's not registered anywhere. It's a private irrevocable trust between you and the trustees. So no, it's not registered.
Okay, it's like any contract, you just keep it to yourself.
Correct. And,
okay.
You know, the only time it would be known to somebody
Randall,
else.
is there any way you can increase your volume, like get closer to your mic?
Sorry. Sorry. The only time that trust would be known to anybody else is if the trust itself creates a contract with a third party.
Okay, in fighting with, say, opening a bank account, have anyone experienced any difficulties? Some banks are very particular.
Yes, you may have to shop for a different bank. I've had that situation a number of times.
I do have one that's with the IRS EIN, and I finally found a bank to accept it, and it's a charitable religious trust, and basically it does not do business. Does your trust, can you do business?
Yes.
Good. Such as, well, there are various programs. The answer is yes. Thank you very much. That takes care of me. Thank you.
Thank you, sir. And I wanted to add that in our experience, that I can think of, the only time a natural law trust has a need to be registered or posted anywhere is if it owns real estate and you want it on the county recorder record that the trust owns that property. Otherwise, it has no requirement to be publicly posted or registered anywhere, and that's one of its protections, to keep it private.
Correct.
Hmm. Well, I'm interested in private placement programs, and that's why I was asking about business. But on the charitable religious trust, basic housing is basically donations in, donations out, and housing assets, but no business.
Yes, you can do that with a natural law trust.
Okay, my friends. Thank you again.
Thank
You're
you.
welcome.
Okay, we have a Canadian, Emerville asks, Canadian politicians are suggesting taxing the equity in people's primary residence. Could this be bypassed by having the residence in a trust?
Depends how they pass the law in Canada. I would probably, I'm sure it will be tested before it gets passed, or if it gets passed. I mean, that's pretty absurd that they would tax your equity. I mean,
they must be
but-
scraping the bottom of the barrel.
well, you know, your property taxes will go up each year, and every time somebody builds a new house within a vicinity of your old house, you have, I mean, in New England, we had lived in 200-year-old houses, but when they built, and even though the house is 200 years old, even though they built a new house next door to you, that it would affect your tax base on your own property. So yeah, it's bizarre. I won't go into that process.
Okay, Jay asks, if you choose the grantor manager beneficiary model, is the manager an employee of the trust?
No, independent contractor. Any way that you want to set it up with the trustees, not an issue.
That's a
I mean, I'm all for independent contractorship anyway. So employees is an old terminology unless you have to work for a company.
right. Okay. So, Randall, would you like to share any other information that is of interest to the listeners while we're waiting for more questions?
Well, it's interesting. My Spectrum TV went out the other day, and I haven't had TV for 3 days, but that same day I received a package in the mail with this new book I've been kind of jonesing to get my hands around. And sure enough, I've just kind of been absorbed into this new law book. So I'll be sharing that probably next month, or certainly into the next process of time. It's this very stimulating idea or summation of what we do here with Natural Law Trust. And those of you that have our document, if you often, excuse me, I often get questions and I say, okay, what? Here, go to section here, this section, this paragraph, this part of that, section 6.5, and that should give you the answer to your question. And rather than me telling you, you have gone and reread those 2, 3, 4 paragraphs so that you have more understanding. So one of the first things I do is reflect people back onto the document that they have in hand. They go into the trust manual that they get with the document. They have your ebook is available, and there's a bibliography that you have on the EIC website. I don't expect any of you to have to read all of those, and it's only if you want to mentor with me as a trustee that I would say, well, the first thing you do is you have to read at least 2 of these, 6 or 7 books that I have listed here. I don't expect you to read them all, but if you really want to do this, then it would behoove you to do that. It's not like having to go to law school, but it is becoming very somewhat savvy in how to be a really good trustee.
All right, JB asks, are there any specific pros or cons of a trust having a DBA?
Yes, that's always something. Like a number of clients they already have a business, and I say, okay, we can do 2 things, or we can do a couple of things. We could leave the business in your name. We could put the business in the name of an LLC. And then the trust would be, we could assign the business to the trust, but I prefer if it's an active business that maybe another entity is used as a storefront and the trust is the back office. So you have the storefront, which maybe contains some liability factors. So rather than having the trust have that potential liability, I would say and I've run it a couple of times myself, where the LLC is a storefront and the trust is a major percentage member of the LLC or the S Corp.
Good question, good answer. Awesome. Okay. So Ocean asks, when opening up a trust bank account, it will ask for your social security number. Should we put that down, or what should we do?
Depends on the bank, but typically in my scenarios here is if I take the trust document and I take certain copies of it that we give instructions to do, and I go in with the IRS EIN number, other than my ID, I'm not typically asked for my social security number, because it has nothing to do with my social security number. It has to do with the EIN number that we've gotten for the trust document.
And also, there's the issue that the client can appoint anyone they wish as the responsible party. Yeah.
Yes, that's correct. We did that in the early days to some extent. Also, we would go out and buy a person's ID and social security number for, a small sum, and then we would use that to be would be the responsible party. But then once the EIN number is gotten and the account is gone, then it's inherent on the trustees and the beneficiaries to make this thing work without any fraudulence or jeopardizing the assets.
Yeah.
It's a complex irrevocable trust, but once you learn the gist of almost all the sections within the trust document, it's not that complex. It's fairly simple. There's a terminology difference. A simple irrevocable trust means that basically the trustees have to dispense with interest on a regular basis. So if it's let's say it's an investment portfolio, and the investment portfolio is paid on a monthly basis, or interest comes back on the turn of an event, that potential profit must be given to the beneficiaries. So that's a simple irrevocable trust. With our complex trust, the trustees have the discretionary power, and so that makes it a complex discretionary trust where the trustees can decide to hold it, and the new potential profit can be held within the trust, or it can be given to the beneficiaries.
We have the gentleman from the 323 area code. I'm going to ask you to unmute, sir.
Can you hear me now?
Yes, sir. And what was your first name?
Gerald, Gerald. Just a little side note, something I've learned along the way, have not used it yet, which is through these, can be used by anyone, but you gentlemen as well, is through the state of Nevada. Through the state of Nevada, they have a business trust, which is very reasonable, 600 and a few bucks or whatever, one-time charge. You can also use their mailing address and their telephone service for annual charges. And basically, let's say 3 people, a DBA, a corporation, a trust, whoever, it's likened to an REIT. Basically, you file with the state of Nevada. All they want is a great insulator, masking off. All they want are the names of the trustees, as they call them, of those 3 entities, or more or less, of those entities. And that's all they want. Is, okay, there's a new company coming in on this deal. Who's a trustee in the name of that company? You tell them within 10 days of a trustee coming or a trustee going, and then there's an annual report of the existing trustees on that annual basis. Very simple, be helpful to many people, and the trust involved comes into one account according to the agreement among those trustees. The money is split, divided accordingly, like an REIT, and it goes to the particular trust company, whatever. And just a little suggestion, it may work, may help you. Thank you.
Well, do they open up a bank account for you as well?
They did at one time with Wells Fargo. They did corporations sole at one time, but since the Patriot whatever Act, they stopped doing a lot of things. The answer is, as I know it right now, no.
Yes, that's correct. I've gone through that process, and South Dakota also does really good agency work, but you still have to go to a particular bank now in person, show your ID, take your mask off so they know who you are. And so yes, that whole Nevada thing works on one level, but you still have to go get a bank account.
Well, no, I agree with you. That's understandable. And once the funds come in, again, like into an REIT, Real Estate Investment Trust, is when the money comes in, it's divided at the bank to the participants. But just a little extra insulation.
We can do that with our trust. So there's no distinctive flavor to me in that process. There's no reason why you can't have a natural law trust and do the same thing.
Just passing it on.
Thank you very much.
I'll pass the talking stick. Thank you.
Thank you, Gerald. Okay, Ocean asks, if the home is conveyed into the trust, how do we address property taxes? Does the allodial title help?
Does the trust have a allodial title? That's the first question. If it's got a mortgage on it, then no, it wouldn't have that. And have you enough knowledge where you can track a allodial title back to the original land grant? That's something I've been discussing with a couple of friends and clients recently. And allodial title is a thing that the government clamped down on really hard a while ago. I don't know what the status is now, but they don't like it because, of course, they want you to be in their tax base, just like they want you to file a 1040 and a 1041 form. So that's a tax issue, and I don't want to get into it. But allodial title is very different than just putting your asset, your house. If you have a mortgage on your house, it'll follow into the trust or whatever entity, Corp Sole, or whatever entity you put it in. If it's not in allodial title, then the tax base will follow the land property.
While we're talking about the law, since this series is on the topic of trust law, I've found it fascinating, Randall, that we can comply with, or let's say harmonize with, all the greatest forms of law on this planet, from universal natural law to the UCC, which is global, and even harmonize with statutory law without the trust being subject to it. So would you like to comment on that?
Well, yeah, I think it's very important is that when you have a private irrevocable trust and you and the trustees have done your proper work and education, then it really stays out of all of that mess. It can weave in amongst all of common law, maritime law, all of that. Trust law, equity law, common law, and maritime law, UCC, are all just contract law, under contract. You have equity and you have a contract, one or two. And the thing about the natural law, we've set it up, and our experience over the last 40 years is figured out, okay, how do we weave within all these different packages? And that's what I like to do.
You boiled it down to the essence of contract law, which is pervasive throughout all other forms of law.
That's exactly right.
And that's why
my word is my bond.
The trust has never been penetrated and has never been invalidated and cannot be invalidated. However, and knock on wood, Randall, so far you've helped people stay out of trouble, which is awesome, and it's a miracle. But if there ever were litigation, it would only apply to specific actions of specific officers, right? It would just be
Correct.
limited jurisdiction for specific transaction and not the trust itself.
Correct. The document is never in question. It's the performance of either the trustees or the beneficiaries. So the document is held its own. I mean, it's been passed to me, it's been time tested. And yes, and part of the powers of the trustee that can sue and be sued. So it doesn't mean that the trust is inviolable. What the trust document does is set it up so that all these things can happen, and it's up to the trustees to defend that position and not commit a breach of contract, breach of trust, etc. So that's what we're talking about. We're talking not necessarily about our contract, which we've used over and over and over again, but it's the players involved, which is always basically the case.
Very, very important point, and really makes me happy to have that clarification. I think everyone in the world should understand that, Randall.
Well, that's what we try to do, and I think you've done a good job. I've done a job, and I keep referring people, have you read the trust document? Would you read it again? How long has it been since you've had the trust document? Well, I got it last year. I said, well, have you taken it out? Have you done the minutes for this year? Have you looked at it? Have you talked with your trustees? So it's important to stay current. I know a lot of clients were just waiting for a certain action to happen so that they can really use this trust the way they want to. And in the meantime, stay up to date on your knowledge and stay up to date on what needs to be done to keep the trust viable, certainly on a yearly basis.
And it looks like we have the privilege of hearing from Gerald again. Gerald, I'm going to ask you to unmute, please. Go ahead.
I'm being a pest. Just to let you know that our Bill of Rights, our Constitution, guarantees an agreement no matter how it's written. So you have that legality we all know anyway to back us up. So again, I'll stand down. Thank you.
You're welcome.
Well, Gerald, even beyond the Constitution, we have U.S. Supreme Court cases that
I know
reaffirm that right. But on the other, the trust is international, so the contract law goes worldwide, and we want to honor those from other countries who, can't rely on our.
Exactly.
Yeah.
I'm just passing up for newbies. Just sharing.
Fantastic.
I agree with you.
Thank you. You can be a pest anytime you want to be.
Okay, thanks.
All right, we have, in the case of the trustee going bad, what court is used to bring justice? Who's to know, since not much is recorded in the natural law trust?
Well, it would be a suit being brought before the court, either court of equity, or if the trustees have done criminal action, it would be in a criminal court, but it's either equity court or criminal court. It would, if the trustees go bad or fraudulent and the beneficiaries think that that's happening, the beneficiaries can bring suit. If the trustees feel that the beneficiary has gone astray, then it has recourse as well. So it's checks and balances like anything else in life. Businesses, if somebody's not managing it properly, then there's actionable recourse, and same thing with a trust.
I'm just curious, Randall, have you ever heard of that happening to any of our clients in the 3 or 4 decades you've been doing this?
Well, it may have happened, but I've never heard about it. I've never had anybody call me in a panic and said, hey, this is happening. What am I going to do? So I don't have that experience.
You would think we would hear about it if it had happened.
I would think.
That's a fantastic record. Maybe we're just lucky to attract really nice people.
I'm sure that's part of it. And part of it is our educational process. I remember there was a group in Nevada and groups elsewhere, and they just sold you, a trust contract for $120, $200, but there was no consulting with it. It was just set up, was established. Maybe they got you an EIN number. Then it was up to you to go to the bank and deal with it from there. But there was no recourse for you to call them and say, hey, well, these guys didn't want to do this. What do you think's happening? So yes, I think that's one of the unique things that we do is we give our clients significant consulting and education to make sure that their trust is run in a viable manner.
It might be useful, Randall, for us to mention too that you are accepting proteges to study under you, to be trained to learn how to be professional trustees.
I am, but I'm not in a rush, and I'm certainly not looking for a waiting list. But if you're serious, then the first thing I'm going to ask is that you go to the bibliography that's posted on the BIC website and start to peruse that, see how expensive it is to maybe learn how to be a trustee. If you have a good resource of a library, a law library, perhaps you're in a place where there is a law library, then you can get the essentials. You got to have a passion for it, though.
Yes.
So it's either hit you or it doesn't. So I would encourage anybody that has an interest to, if you're a client of ours, that you just drop us an email and we'll go from there. I don't mind it at all. I'm working with a couple of gentlemen from yesterday, and it's kind of exciting to have a little group, subgroup, and they all want to do this. And it's like, okay, I'll just be the mentor, and this is what we have to do. And your questions come to me, and we go from there.
Okay. Ocean asks, what kind of EIN can we obtain with the Natural Law Trust? From IRS online generated, or or 98?
No, you just go online. Takes about 10 minutes. It's Central Time, I think, the IRS Central Time online basis. So wherever time zone you're in, you have to coordinate for that. But between, say, 10 o'clock and 4 o'clock Central Time, you just go online, put in the the name for the trust, who's the responsible party, who's the trustee, address, etc. A few minor things. If you're a client of ours and you have gotten our document, then you will have a link to that online process and a 2-page, it's a form that's already made out and shows you exactly which dots to connect and which boxes to check, etc.
And for other countries, you just go get the business number that any bank would require to open a trust account.
Yes. I know in Britain, numerous clients just walk in, they don't need a number, there's no number for the trust entity. In Canada, they have I have a link for that online service. Australia is a little different. I think people have to mail it in down there, but
Margaret says it's the ABN, the Australian business number.
You're right. If you have one, fine. Or if you know how to do that, I've never gotten a link to their online process, so I don't know.
Yeah, Margaret, could you share the web link for that so that we can help other Australians? That would be nice. I mean, you could email it to us or
Right. Thank you.
text. Yeah, thanks. Any other comments before we close? By the way, you're looking good, Randall.
Coming back.
For the benefit of those who haven't gotten to know Randall that well, he's lost a couple of family members in the last few years, and he went through a little bit of a hell with that. And Randall, we're so happy to see you back. You look healthy, physically, mentally, emotionally, and spiritually.
Thank you very much, my brother.
And I've got a lot of comments coming in saying they agree.
Could be the background. It's all your fault.
No, it's you. It's both. All right, everyone. Thank you so much. Wednesday, October 21st was today's webinar. The next one, November 18th, is next month. And that'll be the last for the year because we take a break in December. And I'll just go ahead and conclude house-of-freedom-trust.com for those who don't have a web address for the trust, but if you have an affiliate link, we would prefer that you use that, please. And 360-200-7521 for those who need a phone number. When it rains, look for rainbows. When it's dark, look for stars.
Very well put.
Well, mahalo, aloha. Oh, Margaret has sent the link. Thank you, Margaret, and we'll save that for everyone. Okay, I'll get it over to you, Randall.
Okay. Thank you very much, Tanzan. Aloha to everybody. It's been wonderful to be here. Thank you.
Aloha.
You inspire me to get healthy and look good again. Thank you very much.